So welcome, everybody. My name is Peter Zimroth. I am the director of the Center on Civil Justice at the NYU Law School. For those of you who are new to the center's events, our center is dedicated to the study of the civil justice system in the United States and how it can fulfill its purposes. The center's mission is to study and improve the civil justice system in the United States. Some of the most distinguished judges, lawyers, and scholars in the country sit on the center's board with roughly equal number of plaintiffs and defendants lawyers. One of the members of our board, Evan Chesler, suggested this conference, and he will be participating in today's third panel. The center is focused on several aspects of civil litigation, from aggregate litigation to third-party litigation funding to data and technology in the courts and more. We've also touched on specific subject matters such as the opioid crisis. This event is the center's first foray into the field of firearms litigation. However, many of the substantive and procedural issues to be discussed today will be familiar to those who have followed our work, including our work in class action, MDLs, and litigation strategies. We are very glad to be partnering today with two other esteemed academic institutions in presenting this conference. First is the Duke Center for Firearms Law. It has been a leading voice in academic research on firearms litigation. And we'd like to thank Jacob Charles, the executive director, along with co-directors Joseph Blocker and Darrell Miller. Joseph and Darrell will be participating in today's event. Second, we are happy to be partnering with the Solomon Center for Health Law and Policy at the Yale Law School. We have partnered with the Solomon Center in previous events, represented here today by Abby Gluck, its founding director. Abby has been invaluable in planning this and also in other events of the centers, as well as in participating and offering very keen insights about those events. So a few preliminary announcements before I introduce our first panel. We will be providing 4 CLE credits. To receive credit, you will need to submit a form that we will email each of you within 24 hours of today's event. The form will ask for several codes. These codes will be given at different points during the conference. Please write them down. We will also be fielding questions at several points during the event. Please type your questions into the Q&A box at the bottom of your screen. The Q&A box is next to the chat button, so you'll see that. We will select among them and read them aloud. We'll try to get as many of the questions as time permits, but I can't promise we will get to all of them. So the first panel is entitled Liability, Litigation, Products, Preemption, and PLCAA. For those of you, many of the people on this call know exactly what PLCAA is, but for uninitiated like me, I had to ask, and it stands for Protection of Lawful Commerce in Arms Act. The moderator will be Abby Gluck. Abby is a professor at the Yale Law School, as well as the Yale Medical School and the Yale Institution for Social and Policy Studies. As I already mentioned, she is the founding director of the Solomon Center. Before joining the faculty at Yale, Abby was a professor at the Columbia Law School. Previously, She worked for New Jersey Governor John Corzine and the New York City Mayor, then Mayor Michael Bloomberg, and in numerous other senior government positions. She began her legal career clerking for the then Chief Judge Ralph Winter on the U.S. Court of Appeals for the Second Circuit. And then for Supreme Court Justice Ruth Bader Ginsburg. She has also been affiliated with the Paul Weiss firm. And please welcome Abby Gluck and the first panel. She will be introducing the members of her panel. Abby?
Thank you, Peter. It's such a pleasure to be back here to see you virtually and to see everybody else. My computer's been having some audio trouble, so if anybody does not hear me, please do let me know so you can hear me. PLCAA, as Peter said, is a statute that confers significant immunity on various lawsuits involving gun litigation, and we're going to hear all about that. I am going to introduce our terrific panel, and then we're going. So that's someone, and we would someone is on their conference line, so it'd be great if you could mute that. I'm going to be introducing our four terrific panelists, and then we're going to have opening remarks from each of them for about 10 minutes. And then we're going to have some roundtable Q&A among us, and then we hope to have a robust discussion with all of you. I'm going to introduce them in the order in which they will be speaking. First, we're going to hear from Alla Lefkowitz. She's the Director of Affirmative Litigation at Everytown for Gun Safety, where she achieved the largest settlement against the gun industry since the passage of PLCAA. We're going to hear all about that. Prior to joining Everytown, she worked at the Brady Center to Prevent Gun Violence and the Skadden Arps firm. Then we're going to hear from Mark Lanier. He's a founder and director of the Lanier Law Firm. He's widely recognized as one of the top trial lawyers in America. He played instrumental roles in some very significant aggregate litigation cases over the past several decades, including the Vioxx case and the Johnson & Johnson talc litigation. And he's been a significant player in firearms litigation, including in the Remington case. Then we're going to hear from Timothy Litton. He's the Associate Dean for Research and Faculty Development and Distinguished University Professor and Professor of Law at the Georgia State University College of Law. His work has appeared in the Texas, Virginia, Cornell, Northwestern, and Wisconsin law reviews, among others. He recently edited Suing the Gun Industry, a battle at the crossroads of gun control and mass torts. Finally, and last but certainly not least, we are so delighted to have Attorney General William Tong from my state of Connecticut. He is the first Asian American elected at the statewide level in Connecticut. He was elected Attorney General in 2018. Prior to that, and we're very excited about this aspect for his remarks today, he served in Connecticut's General Assembly for 12 years, passing numerous instrumental laws, including involving firearms. Prior to joining the legislature, he was a litigator at Simpson Thacher and at Finn, Dixon, and Hurling. And I should say thank you to Joe Blocher, who's also a great friend, and the Solomon Center at Yale University put together a new issue of the Journal of Law, Medicine, and Ethics, which Joseph participated and others here were involved. Timothy was a wonderful editor on one of those articles that talked about a lot of the issues that we'll be talking about today. So if you want to read more, look out for that volume. I'm going to turn it over to Alla, who I think is going to share her screen and get us kicked off to sort of give us the landscape of what PLCAA is, how it's affected this litigation landscape, and then we'll go to Mark for some more focused commentary on different kinds of actions.
Abby, thank you so much for having me. I thought that a good way to start us off here would be, as you say, just giving a basic introduction to affirmative gun litigation and PLCAA specifically, so we're all kind of on the same page when we're having these discussions. I'm going to try to share my screen, and hopefully you will tell me if anything goes wrong. Hold on just one second. David, I'm wondering if you can maybe share the PowerPoint.
No problem. You can just let me know when to move on.
Cancel. Yes, wonderful. Now? Yeah, perfect. So yes, why don't we move on to the next slide?
Okay.
Sure. So I think it's really important to understand when we're discussing affirmative gun litigation, the universe that we're dealing with. PLCAA is obviously very important, and that is the federal gun industry immunity law, which was passed in 2005. But there's other laws that are equally as important. One of them being the Tiahrt Rider, which is another federal law passed in 2003. And I'm not going to spend a lot of time on it here, other than to say it makes it very hard to get information about who your potential defendants are going to be. If you don't know who sold the firearm that was used illegally in a straw purchase, it's very hard to build a case without a defendant. And then another important aspect is there are over 30 states that have statewide immunity laws. They are very varied in scope. Some only apply to municipal plaintiffs and allow victims of gun violence to bring litigation, and others apply to everyone. Some state immunity laws have sanctions. So in other words, attorney's fees. So if you lose the case, you would owe the victim of gun violence would owe the gun company attorney's fees. That's not something that PLCAA has, but some states do have that. And importantly, some of these state immunity laws also shield actual illegal activity by gun industry members. So we'll go into this further a little bit, but PLCAA doesn't shield knowing illegal activity, but some states actually do. David, if you could go on to the next slide. So when I'm building a case, I really like to think of it kind of as an obstacle course with four hurdles in it. The first one, as I mentioned, is having the access to the information. You need to know who did what before you sue them, and that frankly gets rid of a lot of cases right there and there. And then the next step is making sure that the claims that you're going to bring fit within an exception to the federal gun industry immunity law. That's PLCAA, and we're going to go into there's 6 exceptions, and we're going to go into those later. And then the next step is to make sure that the claims that you have fit into the state immunity laws. And then finally, and again, equally as importantly, you have to make sure that the cases, the claims you have actually are recognized in the particular state as a viable theory of law. So you have to have all 4 things before you can bring a claim against a member of the gun industry. David, if you want to keep going. Here's the Protection of Lawful Commerce in Arms Act. I think these are the key aspects. Basically, what PLCAA does is it bars all civil lawsuits against members of the gun industry for pretty much everything, as long as it's a case involving the criminal or unlawful misuse of a gun or ammunition. And again, basically that's if there's a shooting, a criminal shooting, then your case will likely be barred unless it fits within 6 exceptions. And I've just noted here the 2 of the key provisions of PLCAA, which says that a qualified liability action cannot be brought in any court, and then defines what a qualified civil liability action is, which again is pretty much any kind of civil proceeding or administrative proceeding against anyone associated with the gun industry, including the NRA or NSSF, for anything, if it involves a criminal or unlawful use of a firearm. David, do you want to go on? And then we have, importantly, 6 exceptions to PLCAA. I've only listed 4 of them here. And that's because 2 of them I've never actually seen used, and they're pretty worthless. But these 4 here I think are important. And I think what's important to note first is what's not on here. And that is you cannot bring a claim for ordinary negligence. Which, again, takes out a large swath of the vast majority of cases that you could possibly bring against a gun industry defendant. So the first exception that I'm going to go into is something that's come to be known as the predicate exception. And what it says is that a gun industry defendant that knowingly violated a state or federal statute that's applicable to the sale or marketing of a firearm can be sued. So in the classic case, if you have, for example, a gun store that didn't do a background check and sold a gun to a felon, and that felon then used the gun, PLCAA would not bar that action because in that case, the gun store has violated the Gun Control Act. An example of a case that's been brought like this is a case that we have, my team is working on right now, which was filed on behalf of the city of Kansas City, Missouri, against 4 gun dealers and 1 manufacturer. And what happened in that case is a gun trafficker by the name of James Samuels trafficked 77 guns into the city of Kansas City, Missouri. And, and we asked ourselves, well, how did that happen? And the way that happened is that this gun trafficker used complicit gun stores and a gun manufacturer to illegally get these guns and then to sell them to, through straw purchasers to individuals who are legally prohibited from having those guns. So as one example, James Samuels actually called up the gun manufacturer, said that he was a part-time employee of a gun store and just wanted to buy guns directly from the gun manufacturer, which is illegal. The gun manufacturer over a year sent James Samuels 32 guns, handguns from Nevada to Missouri. Some of them he even shipped them, the manufacturer even shipped to James Samuels' home. So that's the kind of case, it's a rare case to see such blatant illegal activity. But that's an example of that kind of case. And we were able to allege there that the defendants had illegally shipped handguns over state lines, aided and abetted dealing in firearms without a license and so forth. So that case is still ongoing. But there are other cases that I think will probably be discussed later that involve a broader concept of what a statute that's applicable to the sale and marketing of firearms is, and that is using a statute like unfair trade practices statute that is not directly applicable to firearms, but can be applied to the sale and marketing of firearms. And that's exactly what was done successfully and famously in the Soto v. Bushmaster case from this in the Supreme Court of Connecticut, and that was issued in 2009. So that's the predicate exception. And then the next type of case that can be brought is a case for a negligent entrustment or negligence per se. And importantly, that kind of case can only be brought against a seller. And I'm going to talk about that a little bit later on. But then finally, the last 2 exceptions really are product defect cases. And I think Mark is going to go into them a little bit, probably in his section. But I think the important thing is that last section, the last exception, in which a claim is allowed to be brought when there is a design defect for a firearm, unless the firearm was used, was caused by a volitional act that constituted a criminal offense. So this, except basically if there's a shooting by someone who can form the mens rea to, point the gun and intend to shoot someone, even if it's someone like a 15-year-old child, PLCAA makes it very, very difficult to bring that kind of case. So, so this ends up being a much narrower exception than one might think at first glance. So, David, if you could go on to the next, I already talked about this, so and you could go on to the next slide. I think it's the last slide. So I just wanted to quickly touch on what negligent entrustment is before I finish up. And just to say that this is really a kind of tort that has been really recognized for centuries. Famously, it was recognized in 1816 in England, and again, the Supreme Court of Connecticut recently acknowledged also that this concept of entrusting a firearm to someone who cannot handle it has just been recognized for centuries. And I think in the Soto v. Bushmaster case, the Supreme Court actually cited to the Republic of Plato. So generally, negligent entrustment claims have been used when a car is given to someone who is maybe habitually drunk or someone who doesn't have a driver's license. But since the passage of PLCAA, because this is one of the few types of cases that can be brought against gun dealers, there's been a lot of work. There's been a lot of cases that have recognized negligent entrustment liability for gun sellers as well. So I think that's the intro that I wanted to give, Abby, and I'll turn it back over to you.
Thank you. That was just terrific and really a wonderful background into the statute. And I think you're right that these exceptions on first glance look broad to the naked eye. And then when you see how they're applied, they're actually much narrower. than one would expect. We're going to go to Mark now, and he's going to talk to us about product defect litigation, and also maybe a little bit of complex civil litigation if time. And if he runs out of time, I'm going to come back and ask him about complex civil litigation at the beginning of the Q&A. Mark, we can't hear you, so let's just work on the sound.
Now, can you hear me?
Yeah, perfect.
I'll begin with a thanks to you, Abby, for the kind words in the introduction. And of course, thanks to NYU for putting this incredible panel on. And to all my fellow panelists, I'm honored to be with you, and to everybody listening. Now to business. Let me give you two fact scenarios. Scenario one, Tommy comes into my office with a crutch, an artificial leg, accompanied by his fiance. He sits down and I say, "What's up?" And he says, "Well, I'm from Idaho and I have come to Houston to see you because I need your help." I said, "Why do you need my help?" And he taps on his artificial leg and he says, "I didn't always have this. I was hunting with my fiance using a Remington 700 rifle. The safety was on. The rifle misfired, went through the bullet went through the car door, shot my leg up, and I lost my leg." I said, who was holding the gun? He said, "My fiance." I said, "Okay." I'd handled a lot of Remington 700 misfire cases. I knew what to do with that. Fact scenario two, December 14th of 2012 in Newtown, Connecticut. Adam Lanza, 20 years old, goes into the elementary school, Sandy Hook Elementary, and starts shooting using a Bushmaster rifle. He kills 26 people in the school, having already killed his mother earlier in the day. Those two scenarios provide some bookends to the kind of litigation that I'm familiar with mostly in firearms cases. And I'll tell you three things in the short time that I've got for my introductory remarks. First of all, the individual case. The case where Tommy comes in and his rifle has misfired. I've had those cases that are death cases. I've had those cases where people have lost foot because their gun's pointed down, shoots their own foot. I've had those cases that are a leg off case. Those cases are easily handled under the law if you can prove the product defect. The Remington 700 was famous for having a bad trigger. And so we took those cases and pursued those cases, and I never had to try one to a verdict because they always settled. It was a known problem Remington had. Those types of product cases that Ala's already been talking about are viable cases, all things being considered. But go to case number two, scenario number two, go to the mass shooting case. In Sandy Hook, Ala made reference to the fact that the Supreme Court of Connecticut upheld the case as far as the ability for it to proceed. But it's worth delving into on a little bit more factual basis, at least from a trial lawyer's perspective, which is the way I look at it. The big difficult problem is, of course, how do you get around President George Bush's PLCAA? How do you get around the idea that there is a get out of jail free card for anybody involved in the manufacture or commerce of a rifle if the rifle worked, or the firearm worked, not just a rifle, the firearm worked as it was supposed to, and the damage is simply the result of someone who has performed in some criminal fashion. So within the framework of that general protection, how do you come under a possible hole that will allow you to, a loophole that will allow you to proceed? In the case involving Sandy Hook, the rifle at issue was a Bushmaster rifle. It was an XM15E25, and that was or E2S, that was a rifle that is arguably suitable only for military or policing applications. And yet the rifle was being advertised, supposedly, for uses beyond that. So the case got filed. It was filed in 2004, right before the end of the year, 2014, excuse me. The case got filed as a class action on behalf of all of the people that were involved. The case gets removed to federal court, gets remanded back to state court. After the remand back to state court, the gun owner, and Remington, by the way, is who owned Bushmaster at the critical time. So this is Remington as the defendant. Remington files a motion to dismiss under PLCAA. The judge does not grant the motion to dismiss. Remington then comes up with a reason to refiles it, and upon the second filing, the judge grants the motion to dismiss. That's the case that went up to the Connecticut Supreme Court. The argument in front of the Supreme Court was that the consumer statute doesn't allow you to falsely advertise, and the consumer statute was violated when a gun that was meant for policing applications and military applications was being marketed ostensibly for common use. And so based upon that, the Connecticut Supreme Court sends the case back on a 4-3 decision. Remington takes it up to the U.S. Supreme Court to try to get that reviewed. The U.S. Supreme Court says, no, not at this point in time, and let the case proceed. Case goes back to state court. In the meantime, Remington files bankruptcy. So that case is currently stayed under the bankruptcy provisions of stay. And so what's going to happen to that, who knows? But in the event there is a successful outcome for the plaintiffs, that will no doubt go up to the Supreme Court as well. But it brings up one last point that I'll add to the initial cauldron of brew that we're creating here. And that is, what do you do with class actions? How do you handle a class action? It's really hard to handle one on the issue of personal injury damages, since AmChem, those are basically booted out per se. But we were successful at filing a class action against Remington. We filed it in Kansas City. We took it up we got it certified by the judge. Our class were owners of the Remington 700 rifle. And we argued that they all sustained an economic damage because they had a rifle that was not suitable for any good use and shouldn't be used. Our big issue was to try to get Remington to replace the faulty triggering mechanisms with a good one. The judge upheld our class, but it did go up on appeal. The Court of Appeals upheld the class as well, Federal Court of Appeals. And so ultimately, we started getting those guns fixed. That type of a class action will work in an economic situation where it will not work. Though then again, you still have problems of how to provide notice and all of the typical class problems that especially arise when you're dealing with guns and gun safety and gun ownership. So from a smattering perspective, those cases set before you is my view of the world as a trial lawyer. Cases which are successful, cases which are ingenious, but the jury remains out on whether or not success will be there.
Mark, thank you. And thank you for that stirring the brew analogy. We are going to go to Tim, who's going to step back a little bit and talk about the broader litigation and regulatory landscape and how these cases have developed before going to the Attorney General.
Thanks so much, Abby. I also want to thank the organizers of the symposium. This is a nice opportunity to address an important issue. The United States generally takes two approaches to gun violence control. One of them is marketing restrictions, things like background checks or restrictions on sales or distribution of firearms. And the other is design modifications, bans on high capacity magazines or barrel shrouds or other types of design features of weapons or their semi-automatic fire. Lawsuits against gun manufacturers are essentially designed to advance these two approaches to gun control. They fall into really two different categories. The first category is negligent marketing theories. These are theories related to arguments that the firearms manufacturers are oversupplying markets beyond what they know the legal demand will bear, over-promoting markets, over-promoting products beyond their legitimate uses, or the failure to supervise downstream distribution and to discipline rogue gun dealers at the store level, or public nuisance theories that essentially claim that sending weapons out into the market is akin to some sort of pollution or contamination. These negligent marketing claims or public nuisance claims are essentially designed to try and create incentives for firearms manufacturers to scale back or to change or to modify their marketing practices. And it's a form of marketing restriction. The second category of lawsuits against gun manufacturers is design defect claims. These are along the lines of the claims that Mark was discussing previously. Things like suing manufacturers for lack of safety features, like indicators that there's a round in the chamber when the magazine has been pulled out of the weapon, or safety locks. And also suing manufacturers for features of the gun related to the gun's lethality. There have been a number of theories claiming that firearms are too lethal, or that they carry with them extra risks beyond what are reasonable or appropriate given the value of the weapon. The federal immunity law, PLCAA, is essentially designed to block these two approaches to advancing gun control through the courts and through litigation, with exceptions for traditional theories. These theories that I'm mentioning, negligent marketing and lethality or design defect or generic liability, these are theories that grew up in firearms litigation beginning in the late 1990s and early 2000s. The legislatures of 32 states and eventually the Congress in 2005 decided that they really wanted to roll back the clock, and they essentially put up an obstacle to these kinds of claims with two general exceptions, or two exceptions that I'll mention. Exceptions for negligent marketing theories. These are old theories, as Ala mentioned, that are, predate the 2000s by several centuries. Things like giving a loaded firearm to a visibly intoxicated person. And manufacturing design problems, things like drop fire problems or improper trigger mechanisms. Those types of things are not barred by PLCAA, and PLCAA didn't really take aim at those sorts of traditional theories. It wasn't an attempt to sort of administer federal tort reform with regard to either garden variety negligence or products liability claims. It was essentially designed to stop novel theories that were developing in the early 2000s, designed to advance, as I mentioned, marketing restrictions and design modifications in firearms. There have been two types of legal assaults in the last 10 years against PLCAA. The first type of legal assault I'll call finding a breach in the wall of immunity, finding some exception, exploiting that, and then trying to open that exception wider. And the second approach is what I'll call the knockdown theory, trying to just basically take a wrecking ball to the wall altogether and knock down the statute. We have an example of the first type or strategy of an assault on PLCAA in the Soto case, which is the case arising out of the Newtown shooting in Connecticut. And in that case, the exception that was raised was an exception to federal immunity for a knowing violation of a state or federal statute applicable to the sale or marketing of a firearm. The plaintiffs in that case are arguing that applicable means can be applied to, not necessarily a statute that's designed to regulate firearm sales, but a statute that can be applied to firearm sales. And the statute that they cited in the Soto case is the state unfair trade practices law, which of course is generally applicable to all commercial sales in the state. This is a type of law which has cognates across the country, and this would represent a significant opening of immunity. One of those 5 exceptions that Ala mentioned, this exception actually would open or be expandable, given that most states have an unfair trade practices law, and it is generally applicable to commercial sales, including the sale of firearms. It should be noted that this particular approach to the exception has been rejected by federal courts, both federal courts in New York in the Beretta case, and also federal courts in California in the Aledo versus Glock case, which is a California nuisance statute. The second strategy that I mentioned is the knock down the wall altogether strategy. And that strategy comes out of Pennsylvania at the moment. There's an intermediate appellate court in the state of Pennsylvania that has declared PLCAA unconstitutional. In that case, there's a design defect claim. Child number 1 shot child number 2 with a firearm, and a claim was brought by the victim against the firearms manufacturer for failure to equip the firearm with a safety device that would have prevented firing of the weapon when the magazine was removed. The state tort claim, according to the court, is not an action of interstate commerce, and therefore is not regulable by the federal government. And furthermore, the federal government's attempt to dictate what cases may or may not be heard in Pennsylvania common law for an activity that doesn't constitute commerce, according to the court, is a violation of the 10th Amendment. That is the right of states basically to not be interfered with in areas that are not already delegated to the federal government by the Constitution. With those things in mind, I think for the meantime, at least, there's very little chance that Congress will decide to eliminate the PLCAA. So we're likely to see more litigation attempting to either breach the wall of immunity or knock down that wall altogether. But we're very unlikely to see, I think, any kind of federal legislative action to repeal PLCAA. I just don't see that there's any appetite for that. And it's the type of issue that probably is not a great swing state issue for many legislators, even in the Progressive Caucus. With that in mind, I think the last thing I just want to mention is I want to just sort of think or open the possibility of discussion on what the landscape might look like if PLCAA were eliminated, given the fact that even though that's unlikely, what would that mean to eliminate PLCAA? Would that really change the landscape? How much is really at stake in this particular debate? A number of things that I would point out are, just for starters, courts rejected pretty much all of these claims prior to federal immunity. So plaintiffs really had a very bad track record. There were no victorious plaintiffs in any suit regarding claims against the manufacturer for criminal misuse of the weapon. It's possible we might see a maturation of these legal theories going forward. Legal theories do mature over time in mass tort contexts when litigation is being brought around the country. It's also possible we might see a judicial shift in views about duty and proximate cause, the grounds on which these cases have been dismissed. CDC might generate new evidence related to causation, which we've seen in other areas of widespread litigation or mass torts. And it's always possible that courts will attempt to address issues of lethality in the product's liability context, which so far they've avoided, but these are the types of things that are still open questions in the absence of immunity. As far as the larger regulatory landscape, and I hope we get into this a little bit in the discussion, I think we really need to ask ourselves, if we were to bring liability exposure to bear against manufacturers, just how much bang would we get for the buck? That is, how much can manufacturers really do to exercise downstream authority or power to police their supply chains? How much power do manufacturers really have to affect the distribution and the leakage of guns into the black market, or to deal with rogue dealers? And if they did, how much effect would that really have on gun violence rates? And as far as gun designs, one has to also ask, given that there is evidence that lethality is a significant public health issue in gun violence and fatality and mortality rates, just how much are we likely to move the needle on gun violence, given that there are over 400 million firearms currently in private hands, many of which are not semi-automatics, and many of which don't have the levels of lethality of an AR-15 platform weapon, but many of which are responsible for a very large majority of what we're talking about in terms of gun violence. So I think we need to also ask ourselves honest questions about to what extent firearms litigation in general, even in the best case scenario, could deliver public health advances that we're seeking.
Thank you, Tim. That was terrific. And I do hope we can circle back to those very questions after we hear from the Attorney General. Two things I wanted to emphasize or say again for those who are new to this topic that you mentioned that are very important. One is this so-called CDC ban on research into, the ripple effects of gun violence, which was construed to be in existence for some 20 years and recently was loosened, I would say, and we're probably likely to see more CDC research under a Biden administration. So that should be very important. The case that Tim highlighted and that Mark and Alla highlighted from Connecticut, that case, as Tim noted, a really significant set of legal questions about the extent to which a general consumer protection statute can be used to justify the predicate exception to the tort immunity, as opposed to a statute that is particularly directed at the gun industry. And I think that's a really good segue to AG Tong, who can offer any comments he wishes, both from the AG landscape, but also he has an amazing background on the legislative side. And as Tim just alluded to, a lot of action going forward may have to be in the state legislatures. And so it'll be great to hear his perspective about what this looks like from where he's sitting. Attorney General?
Thank you, Professor Gluck. I'm jealous of your blackboard, and Mark has his law books in the background. Welcome to the Attorney General's Academy for Young Children. I have 3 distance learners here at home today, and I've got some leaf blowing outside, so I apologize. Welcome to the COVID era, but it's great to be with all of you. And listening to all of you, I'm left with one basic thought. If anybody learns anything today from this discussion, it has to be that elections matter. That's the lesson of PLCAA, right? Elections matter, and the primacy of legislatures state and federal and local ordinances matter too. And of course, also presidential elections make a huge difference in our everyday lives. And I think there's sometimes a temptation to think that all that happens in some fourth dimension somewhere. You know, Congress was reacting to the will of a segment of the American people that happened to hold power at the time they passed PLCAA. And in many ways, it reflected the will of the American people at that moment in time. I know that's a controversial statement, but that's what legislatures do. And so that's what I hope all of us take away from this discussion today, that citizen engagement and legislative action and policy making at the state and federal level is still the main way that we make law and keep people safe. And frankly, for all and others that are in the trenches fighting, you know, in our courts and leading litigation, that's important. What we do is important. Sometimes it's too late by then, or the hill you have to climb is quite uphill after the legislative body has made its decision and its policy decision. So let me just touch on a couple of points, and then, you know, happy to be part of the conversation. Obviously, you know, it's hard to find any community in this country and increasingly in the world that has not been touched by gun violence. Unfortunately, Connecticut has the worst possible relationship you can have with gun violence, and it isn't limited to Newtown and Sandy Hook. It happens every day in our state, and particularly in urban communities and vulnerable communities across Connecticut and across this country. And what grew out of that, and I'll talk about the legislative response in a second, is this case of Soto versus Bushmaster, which is really a frontier legal effort, which I'm grateful for, to push the envelope under PLCAA and under our unfair trade practices laws to hold Remington and Bushmaster responsible for their role in the death of 26 lost souls in Newtown and beyond, frankly. You've all digested the case very well. Let me just offer some quick thoughts about the case that are, I think, important changes in the law. Connecticut as a state was present in the Connecticut Supreme Court as an amicus. It's not our case, not my case. It is a private party case brought on behalf of Ms. Soto and her family. But the really important changes there are, as Tim mentioned, this was brought under the Connecticut Unfair Trade Practices Act. And what CUTPA, as we call it, is a UDAP law. And in every state, there's an unfair and deceptive acts and practices law, a UDAP law. And that's really significant because Connecticut has a really strong UDAP law. It has an expansive and broad UDAP law, but we're not alone in having such a law, which means if we're successful in the Soto case, the plaintiffs in that case are successful, that opens up a lot of possibilities in other states across the country because everyone has a UDAP law. Now, every UDAP law, as I mentioned, is created differently. There are a variety of different limitations on them, including what I would call nexus provisions, basically. How much one has to tie the misconduct complained of to the putative victim. And, this gets back to law school and proximate cause and privity even. And what Soto did, which is really important, is it said, no, you didn't, you didn't have to be a purchaser. There didn't need to be privity between the plaintiff and the manufacturer. You had to be a victim. You had to make a demonstration under the applicable legal standard that you were a foreseeable victim of the misconduct engaged in by Remington / Bushmaster, but you didn't have to be a direct purchaser. And that was a really important development. And also for the really the first time, for the first time in a really significant way, the Connecticut Supreme Court said that an action for personal injury could lie under our state's UDAP law. So that's also a really significant development. So if you want to forecast, where this might go in its potential application to other states and the rest of the country, there's a lot here in the Soto case to work through and to mine for other ideas. I think what it really does also is, and this is a larger question, but because of PLCAA and because it's been so effective, there hasn't been a great point of entry for the states to act together in concerted action, as we did in tobacco, as we do on opioids, for example. I'm in the National Executive Committee of States and Attorneys General leading the opioid fight, as Professor Gluck knows, and my case, which is the generic drug price fixing case, which is nearly a 50-state coalition. We do that a lot, but we can only do that where there's a point of entry for all of us to act. And it doesn't have to be under a single statute, for example, granting us authority under the federal antitrust laws, for example. And it can be our individual states' UDAP laws, but it has to be there for us. And so this might open the door to more attorney general coordination. The final thing I'll say is, Tim mentioned that the prospects for action at the federal level are not great. That's probably true. And it's because Congress has trouble returning to regular order, as John McCain would say it, and discharging its basic constitutional duties, like to pass a budget, things like that. Because of that, the major public policy battles of our time and our age devolve to the states. And we return to our federal system and our federal roots, and federalism becomes important. And that's where state AGs become important. And that's where state legislatures become important. And some of the most far-reaching work in the area of gun violence has been done, I am proud to say, by the state of Connecticut. The very first law that I passed was an anti-straw seller law known as the Lost and Stolen Firearms Law in 2007, where, as many of you probably know, there's a phenomenon with somebody who can lawfully buy firearms, will buy them and then sell them on the street to people that can't buy them. And then when those guns are later used in crime, or somebody's hurt or killed because of that gun, and it's traced back to the original buyer, the buyer says, oh, that gun was lost or was stolen. And so that was a major loophole we tried to close. Unfortunately, the next major action we were forced to take was in the wake of Sandy Hook, and we passed very comprehensive piece of legislation that had a number of key provisions, including what's known as now the suitability test, and also restrictions on large capacity magazines and a lot of other features that many of you are aware of. I was particularly honored, and thank you, Abby, for mentioning this. I was chairman of the Judiciary Committee, which has primary responsibility for our state's gun laws, when I wrote and passed our state's domestic violence gun law to take guns away from domestic abusers. And then the next year I passed the bump stock ban. And last year, my first year out of the legislature in 12 years, we passed the ghost gun ban. What I'll say about all of those laws is there's always a lot of discussion at the outset about whether these laws are constitutional, what's happening in other states. And there's always a lot of discussion and angst and consternation, and it can get pretty chippy in the legislature. One thing I always remind people is, number one, McDonald and Heller clearly stand for the proposition that the states can pass common sense gun laws. They clearly say that. They say other things I don't agree with, but Alito and Scalia both acknowledge the primacy of states in passing public safety laws, even in the gun violence area, to protect people, subject to the limitations as they see them of the Second Amendment. But McDonald and Heller are a good law for that proposition. And I cite that often to people who are opposed to legislative action on gun violence. The other thing is that I often get both legislators on both sides of the aisle, but also advocates who worry about constitutionality, and they worry about their reading of this statute or that statute, and this case or that case. And what I say to them is, something is, the question of constitutionality is a matter for, yes, it's a matter for the legislature, but it's a matter for courts, right? And when I was chairman of the Judiciary Committee, I was no more qualified than the ranking member of the Judiciary Committee to propound on the constitutionality of a particular statute. My job was to do the best that I could, right? To write and pass a law that was consistent with the state and federal constitution. At the end of the day, whether something's constitutional or not, you don't know until the Connecticut Supreme Court or the US Supreme Court or some other highest court of appeal passes on that issue. And so what does that mean to you as a policymaker and an advocate? Do the best you can and push hard. And in many ways, you have to act in a way that is consistent with the Constitution, but in many ways that decision will be made by somebody else. And so do the best you can to pass a statute that provides as much protection as possible for the people of your state. So with that, I'll turn it back to you, Professor Gluck.
Thank you, Attorney General. That was terrific. I have a bunch of questions I want to ask the panel. I see a few Q&A questions building up. I would encourage people to start throwing your questions down there, and I'll start elevating them in the time we have. We have plenty of time for Q&A. I've also been tasked by David Sifford, who deserves a shout out for his fantastic organizing efforts, to read you the CLE code, which I will do right now. Get your pencils out. CC, J like jam, F like flowers, L 1 2. CCJ FL 1 2. Chat me if you didn't hear that, and I will chat it back to you. Let me pick up on Tim's very provocative question, because I can see that some of our panelists are sort of very anxious to answer it. Which is, and I'm going to phrase this slightly differently. I'm going to ask you, what do we hope to get out of firearm litigation? Taking to heart what the Attorney General just said about the heart of action really being legislative. Is it damages? Is there really money here? I've heard from other lawyers that this is not like pharma. There's not big money bringing you in. So is it damages? Is it industry change? Is it discovery? So I think I would love to start with Ala and Mark, the litigators, and let's hear their perspective. And if our other two panelists want to react to that, of course, that would be great. Ala?
Yeah, absolutely. I mean, I think it's all of the above. To answer your question, I think it's damages. I think it's industry change. I think it's getting compensation, for our clients. That's kind of like the most important thing at the end of the day, and getting some measure of justice for people who have suffered really an unimaginable harm. And to Tim's question, about what could really be the true effect of this kind of litigation, and I think it could be really tremendous. If you think about it, the gun industry has really been operating in this era of impunity for the past 15 years or so, with so little viable civil litigation against them, very little criminal litigation, and then you have government entities like the FTC really taking a hands-off approach too. And I think when you have that kind of era of impunity for an industry, that's really, really dangerous. And I just want to give 3 quick examples of ways that I do think that manufacturers directly could really make us all safer. One is in the area of unintentional shootings. There are hundreds of unintentional shootings by children every single year that could be stopped by either chamber-loaded indicators, or by other mechanisms that make it harder for a 2-year-old or a 3-year-old or a 10-year-old boy who finds his parent's gun and starts playing with it to accidentally shoot their friends. That's well known that there's all sorts of mechanisms out there that could make them safer. And that is not being done right now, only because of the immunity laws that are in place. So I think that's one very important that could save hundreds of lives per year. And then if you talk about gun trafficking, one thing that we see over and over again in the kind of gun violence that you see every day, and I'm talking about homicide, I'm talking about assault, I'm talking about things like that, is that there are bad actors in the gun industry who over and over and over again are supplying traffickers, who are supplying straw purchasers and so forth. And this information used to be available on a wider scale. It's not as available now, but there are definitely actors that are, frankly, play very loose with the law. And gun manufacturers and gun distributors continue to supply those bad actors, those dealers. And they could take very simple steps to receive trace requests that are sent to the dealers. So a gun manufacturer knows when a gun is traced in a crime, and it knows that it's sold that particular gun to a certain distributor. The same thing, a distributor knows when it's one of its guns is traced to a crime and that it sold its gun to a particular dealer. If a gun distributor keeps seeing that a disproportionate number of its crime gun traces are traced to one dealer, it should stop selling to them. So that's another way that this could really change the game. And then just marketing. I mean, the marketing that we're seeing out there that is completely, I think, people have taken a totally hands-off approach. I mean, if you go on TikTok, if you go on Instagram, if you go on Twitter, and you see what some of these gun companies are doing and the way they're using cartoons and stickers and videos to really market to kids and to young boys who are interested in, being part of law enforcement and so forth, it's really concerning. And I think that the action could be taken against them as well. So those are 3 areas that I think are hugely important, and that right now, the gun manufacturers are essentially just getting away with anything they want right now.
If I can add to that, the marketing question is a really important one. And, I see a question about expanding liability for manufacturers of other products. And the fact is that as a country and states, we have long held manufacturers responsible for misconduct, particularly in misrepresentations regarding their products and in marketing that is wrongful, harmful, damaging to people in their community. The biggest example, of course, is tobacco, right? Tobacco was not just about smoking, and it wasn't about an adult's right to do whatever they want, and smoking cigarettes or not. It was about targeting young people and children to encourage them to smoke. And the Joe Camel advertising campaign, of which I was a target, right? I'm the generation that wanted to collect Joe Camel swag because it was cool. And because of that misconduct by the big tobacco companies, we had a 46-state settlement. And to this day, billions upon billions of dollars are paid by the tobacco companies to the states because of their deceptive and unfair marketing practices towards children. No would say that we should not take action against the pharmaceutical companies in the opioid crisis, for example, and in particular example, Purdue Pharma, which is in our backyard in Stamford, Connecticut, and the way they aggressively and wrongfully and deceptively marketed opioids and got people to healthcare providers to overprescribe opioids, and the way that those prescriptions were filled by distributors and retailers. So it is beyond question that states can take action for wrongful, harmful, and deceptive advertising practices and marketing, and we do it all the time and often very effectively.
Thank you. I want to hear from Mark. I do want to point out that the opioid litigation, as all of you already know, has had multiple phases, right? And in early phases, those who were suffering from opioid use disorder, we're often thought of that culpable break in the chain of causation, right? Many courts said, well, we can't hold manufacturers, we can't hold doctors liable because the addicts, right, are the ones to blame. And that tide turned, right? There's a very big change of legal momentum. And an interesting question is, what will it take for that to happen for guns? And could it ever happen for guns? And maybe it's already starting to happen for guns. Maybe A.G. Tong's committee in Connecticut and Bushmaster case and Olive's work and Mark's work are all starting to change that tide. But it is interesting to think about other analogous products and how the judicial culture and legal culture around blame and accountability changes over time. Mark, I'd love to hear your view on Tim's question. I'm sensing an audio problem, so let's make sure we can hear you.
Uh-oh, can you hear me?
Yes,
Oh,
excellent.
yeah,
Excellent.
no. I applaud what everybody's saying. And I think that all of you weave together into a common point here that I'll try and drive home if I can. I'll start with where Ala began with the idea of responsibility. And she spoke of 3 different ways that litigation can be used to ultimately ratchet up the responsibility of gun manufacturers. The design decision, the idea of putting something on that enables the gun to be fall into the hands of a child without an accidental go off. I mean, think of all of the different products where this is already true, but for some reason the gun manufacturers have a free pass on it. It's true with your medicine bottles where you've got a child protective cap that that a child's not supposed to be able to take off. Heck, half the adults can't take that one off. You've got lawnmowers. You won't find a riding lawnmower without a kill switch, so that when someone gets up from the riding lawnmower, the blades disengage and they just won't chop off some kid's hand if they're trying to ride the lawnmower. They get off of it and don't know what they're doing. So those design issues are excellent ways through litigation to hold industry accountable for reasonably safe designs. The second one that Ala mentioned, which ties into what you were saying, Abby, as well as General Tong, you both know this in the opioid litigation. The idea of the manufacturer keeping track of what's ultimately going out, which sellers are selling it, whether they're selling it fairly or not. Those types of things are required under the Controlled Substances Act. Now, I'm lead trial counsel for the opioid MDL, and we started one, we got it settled. We start our next one in May in Cleveland. And ultimately, that's a huge problem that everyone in the chain, in opiate distribution chain, manufacturing and distribution, everyone's a registrant. They've got to keep up. They've got to know their ultimate consumers. And those types of safety mechanisms are not in place in gun ownership as well. And then the marketing, General Tong, you nailed it with the tobacco. That's the biggest example I know. So you put all of that together, and courts are useful for that, but you're always going to have, Professor Gluck, you're always going to have your causation problem in any of these cases because of the subsequent intervening cause argument. The way we overcame that so far in opioids, at least through motions to dismiss, is by arguing these cases under the idea of a public nuisance. And so we step them outside of the product case where you're simply manufacturing a product that arguably has a legitimate function. And if someone steps into the chain and makes it an illegitimate usage, your causation destruction happens at that point, and you're not able to win in causation. So there are some different ideas of pursuing some of these things under novel legal theories like public nuisance, where you don't have that type of a causation argument and impediment.
Before I go to Tim, Mark, do you think you could use public nuisance for guns?
Arguably, you could. You've got to have, the biggest problem with a public nuisance is you've got to have an abatable harm. And I think that you could argue you've got an abatable harm. I think that it's ripe for the right people to bring it if you can get through PLCAA. The problem is PLCAA gives you almost a free pass on that.
Because it's a common law cause of action. So
Yeah.
for those who are listening, there's a debate under PLCAA about the way the statute is written, it seems to imply that the only exceptions are to statutorily enacted state causes of action. There are some lawyers in the Brady Center that have been arguing that's unconstitutional, that the federal government is not allowed to tell states what form of a law it's allowed to use. The law students on this should be saying Erie versus Tompkins. So that's the Erie case. So that's an interesting, what Mark was referring to was the fact that you need a statutory public nuisance. I think, Ala can correct me if I'm wrong, that the New York legislature has enacted that or is trying to enact that to overcome an earlier defeat in the Beretta case. Is that right?
Yes, there has been a bill introduced in the New York in the New York legislature to that would recognize public nuisance as a statute that's applicable to the sale and marketing of firearms specifically.
Tim, I want to give you a chance to answer your own question.
Yeah, I'm a lot more skeptical, I think, than the other panelists about the prospects for firearms litigation and what they promise. I think it's important to remember that courts were universally hostile to this type of litigation. That was not ever true, I don't think, with tobacco and opioids. In the early years, there were a lot of problems with assumption of the risk in tobacco. There were certainly cultural shifts that helped move that along. But even in opioids in the early years in the 2000s, there were a trickle of victories here and there. And courts really don't like these cases. They have messy proximate cause issues. They require leaps of policy judgment in terms of duty. Policies that are actually actively being considered by legislatures. Courts do not like to weigh in and say there's a tort duty when the legislature seems to have spent a lot of time debating what the duties of firearms manufacturers are in the jurisdiction. So as far as prospects for success, there's a lot of reason to think that it's going to remain an uphill battle for a very long time. And I realize that things change and cultural attitudes change. But with regard to cultural attitudes changing, there was a large shift in the United States, and it was generally in a similar direction. In the United States, we don't see that. Every time there's a mass shooting in the United States, places like Connecticut and New York pass further restrictions, and places like Florida and Georgia, where I live, pass further liberalization of where it is you can carry a concealed firearm. So in the wake of mass shootings in Florida, we had a bill that went straight to the legislature saying you could carry a concealed weapon on a public campus. So I'm not sure that we're talking about the same kind of cultural shift when we talk about firearms. Firearms culture is in some ways very different than the other types of cultural attitudes we have about other social and public health problems. The last thing I would say is that there's an enormous amount of focus, sometimes too much focus, on the outcome of litigation. And one thing that's really important to remember is the primary impact of a lot of this litigation is not about the outcome. It's about the litigation process itself, the nitty-gritty of filing lawsuits, taking depositions, and arguing motions. And we've seen this over and over again in tobacco litigation, opioid litigation, clergy sexual abuse litigation. The filing of lawsuits frames issues in new and novel ways. The filing of gun lawsuits in the 2000s focused attention away from criminals and onto gun industry practices. That was a very important outcome of the litigation. Discovery often uncovers important information that is resistant to disclosure for regulatory agencies because of the civil discovery rules. And also litigation is an ongoing news item that has a life of its own. It's serialized and it tends to create agenda effects so that public legislatures and also attorneys general take greater notice when things are in the news every day, and they generate a lot of public interest. I would say that the litigation process itself has actually helped focus attention on gun designs and lethality and on garden variety everyday distribution and marketing and sales practices in the industry. But I'm not sure that we have a lot to hope for more than that in terms of discovery. We haven't seen a lot of new information coming out. I'm somewhat skeptical we're going to see things that people don't already know in regulatory agencies. And as far as agenda, there's nothing higher on the American legislative agenda than gun control and gun rights at the moment. So I don't think we need litigation to remind us the way that we have for clergy sexual abuse or opioids or tobacco control.
Thank you. I want to elevate some of the questions in the chat. I'm going to try to combine groups of questions. So there is a group of questions. Oh, let me just also repeat the CLE code because I've gotten a couple of questions about that. So I am now repeating the CLE code for those of you who thought it came without fair warning before. CCJ F like Frank L 1 2. Chat me if you did not hear it. CCJFL12. So we have 3 questions that are all about children. And I'm going to sort of say them all, and whoever wants to answer them can answer them, and then we'll go on to a group of questions about constitutional law. So the children questions are, some of the people are skeptical about this idea about deceptive marketing, asking how is targeting kids with messaging about their Second Amendment rights different than targeting kids about their right to vote. Another question about children is whether we really think things like a loaded chamber indicator could really stop accidents with kids with gun violence. And the third bucket here is about video games and other things that probably do more to market guns to kids. And aren't we fighting yesterday's battle by thinking about magazines and all that kind of online equivalent? Should we be thinking ahead? So I don't know who wants to take that. Alla, do you want to take some of these since you
Yeah,
Yeah.
why don't I'll take the unintentional shooting one because I think that
Yeah.
one, I do think that things like chamber loaded indicators, effective ones, could stop these kind of unintentional shootings. There's a really famous case, an unfortunate case out of the Illinois Supreme Court. I think it came down in 2009, where a young boy, I want to say 10, 11, 12, something along those lines, found a firearm, took out the magazine, unloaded it, but he, didn't know that there was still a round in the chamber. And he was playing with his friends, and he pointed the gun at his friends, thinking there was nothing, there was no bullet in the chamber, and instead it ended up shooting and killing his friend. And this was someone who, this isn't a 2 or 3 or 4-year-old. This is someone who would have been able to read a proper chamber loaded indicator and understand that. It's someone who signified the intent to not actually want to shoot his friend, who really took action he thought the gun was unloaded. Unfortunately we get these updates all the time in my world, and you just see these kind of shootings all the time. So I do think, and that case was dismissed because of PLCAA. So I do think that would make a difference. So I'll take that one.
Anybody else want to talk about marketing?
Yeah, go ahead, Mark.
No, generals first.
That doesn't apply in my house. Let me just say that I think these points are they're not really valid points. They're basically specious, I think, distractions. And the bottom line is this: what they avoid the central truth and scientific fact, and that is that guns are dangerous and they kill people, and they can be used to kill people. And when I debated these laws in the General Assembly, someone would say, well, how is an AR any different than a knife? Or how is it different than a rock, right? Or how, this was in the ghost guns debate, how is just a few pieces that could be fashioned into a firearm that are not yet fashioned into a firearm? How come those are not just pieces of metal, like a block of metal? Because they're not, because they're different, because a gun is inherently dangerous, particularly in the hands of a child or somebody who ought not to have a gun because of one reason or another. Because in a domestic violence situation, as I had to argue in passing the domestic violence gun law, because in those situations, that is one of the most combustible situations between two human beings, and people are apt to get shot if somebody has a firearm. And so the question, the analogies are of limited use, right? Analogizing guns to a lawnmower, for example, Mark, yeah. Right? Or some other household tool, because it's just different. A gun is different, and its intended purpose is to injure or incapacitate an animal or a human being. In the case of something like a Bushmaster, an AR type weapon, the purpose in developing that weapon was to incapacitate, stop, and kill a human being. And so I think a lot of these diversions into video games and isn't this like cars and those don't really advance the argument. Let me just close by saying they're not the same thing in the same way that opioids are not the same thing as aspirin. Okay. Or, by the way, coronavirus is not the same thing as the flu. They're different.
So that answered another question. I was going to follow up with you about the car question, A.G. Tong, but I think you've addressed that. There's the question in the chat about how do we square this kind of liability as opposed to sort of reckless driving liability. Mark, it looks like you want to say something.
I'll add this because I was reading the questions along with you, and one person asked the question of how do you square this, compare it to teaching children about their Second Amendment rights versus
Yeah.
the right to vote. And this goes exactly to where General Tong was. Telling kids they have a right to vote when they get older is not dangerous. But exposing children to the guns certainly can carry that level of danger that the general's talking about. Now, here's where I think a jury trial is extremely useful, because I was reading the questions and someone else asked the question of, hey, well, if PLCAA it is not going to be there to give this security to the manufacturers, isn't it a slippery slope? And why do car manufacturers not have to put breathalyzers on them to stop someone from driving intoxicated or dot, dot, dot? My view of the world is I'm just saying that if we've got jury accountability for these things, then we've got a community decision being made. Then we've got the discovery that Timothy was talking about. Then we've got the opportunity to see whether or not something sordid is going on behind the scenes, and they've got a gun that they're going to then pay to get that gun used in certain video games, so that that model is actually used in the video games and kids are more attuned to that model and know what it is and talk about it the way when I was growing up, we talked about cars. And so those types of things should have a place in front of a jury, because it makes everyone responsible to a greater degree than they are when they have a get out of jail free card. That's my problem.
I think one thing that's important to do is we're lumping together a lot of different public health issues here. We tend to, at the last few moments, lump together injuries that result from accidental or unintentional operation of a firearm, firing of a weapon that doesn't have a chamber loaded indicator, and the kinds of design modifications that might prevent accidents, and mass shootings, where people basically go out of their way to use a firearm to kill a lot of people. And it seems to me that they involve different legal theories and they involve different prospects for success in the courts. I think as far as dealing with accidents and safety features on firearms that will prevent accidents, that seems to me much more consistent with the traditional goal of products liability. And we see this in auto liability. You know, you don't have a sheet metal dashboard in a car anymore. You have a plastic dashboard. So when you crash and you hit your head on it, the car's crash worthy. Cars have been redesigned to prevent injury that results when accidental misuse of the product occurs. And I don't think that we're likely to see, a lot of trouble doing that in incremental fashion. I think the kind of litigation that Mark's bringing against Remington is the kind of litigation we would expect to see succeed over time. And if a marginal amount of that litigation has been barred by PLCAA, as Alice suggests, then we probably could expect to see either exceptions in PLCAA, or if PLCAA for some reason gets weakened or struck down, that type of litigation moving ahead and making a dent, or at least marginal improvements in terms of public health outcomes as far as accidents are concerned. As far as using marketing controls or design modifications to stop things like mass shootings or street violence, I'm extremely skeptical that litigation is likely to do that for a number of reasons, not least of which I don't think judges have a big appetite for this. And I'm sure that judges in the South don't have an appetite for this, and legislatures in the South don't have an appetite for this. I live in a state where people are extremely busy trying to expand people's ability to carry firearms. They don't see the firearm as a symbol of a giant public health problem like tobacco or opioids. They see the firearm as a symbol of American liberty. And you don't need to buy that narrative, but the fact of the matter is about 50% of America votes with that narrative in mind. And so I think that we're mistaken if we think that these are two public health problems that sort of get lumped together in a single analysis. I think they have very different political profiles, and they also have different legal profiles from a doctrinal point of view.
So the next panel is going to be talking about constitutional litigation. And so I'm going to pause on the questions in the chat that are specifically about that, because there'll be an opportunity to talk about those. I do want to ask that we didn't really talk about the mass shooting hypothetical. So Mark, you touched on this complex civil litigation, but we didn't really talk about how litigators are thinking about approaching the mass shooting scenario. And that would be, I think, worthy of a few minutes of discussion before we conclude, since we are the sort of affirmative litigation panel. So I don't know if you or Ala have anything you want to add about what that looks like.
Well, the only thing that I'll add is when those cases come into me and I look at those cases, whether it was a mass shooting, we get a lot of those in Texas, because in Texas, we're a frontier state in a lot of ways. And we use guns to take care of the mountain lions and the water moccasins and other creatures that are around us that themselves are dangerous and destroy life. So guns are readily available and readily used. But even understanding that, a mass shooting situation is almost impossible to do with causation. That's a huge obstacle that would keep me from pursuing most of those cases. And it's also very, very difficult to do with PLCAA in place, because you've got basically a malicious shooter, and PLCAA gives a get out of jail free card. So I look at them, and at this point, I'm kind of like, I'll go after the opioid people instead.
Yeah, no, I mean, look, I certainly agree with Mark that mass shooting cases are very hard to bring for all of the reasons that Mark mentioned. There are actually 2 mass shooting cases that are being litigated in Texas right now. One related to Sutherland Springs that was just before the Texas Supreme Court. And that's I think a fairly straightforward application of an exception to PLCAA that the gun dealer illegally sold the firearm. And then the case that my team has related to the Santa Fe case, in which a 17-year-old who is not allowed to have handgun ammunition was able to order handgun ammunition online, able to use that ammunition to commit the mass shooting at Santa Fe High School. That case is being litigated, and I'm confident that the defendants will raise PLCAA as a defense. But I think we'll see how that goes. We think we have a strong case, but I think sometimes you have to bring these cases to raise awareness to why is a 17 or 16 or a 15-year-old individual able to so easily acquire weapons. So I think I do think they're worth it.
Great. General Tong, you want a final word? You haven't spoken in a couple of rounds. Oh, you're muted. You're muted. Great.
You would think after 6 months of this, I would know how to unmute myself. I think what Ala said is right. And I think, Mark, I hear your frustration. I think, Mark, you know how tough it is in opioids too. And, it's not limited to manufacturers in the addiction industry. It's the entire addiction industry, through retailers and treatment providers and everybody, every link in the chain. And I think I just dismissed analogies, but it's destructive here in that in opioids, in tobacco, often there are frontier legal issues that need to be advanced. And Tim, I hear you, but every incremental step forward it can be a major change. And I think the culture is changing. Unfortunately, as a former legislator, sometimes it takes a real tragedy to move not just public opinion, but legislative action. And you have to create a real baseline for that change. And I think moving the law forward, filing cases that are tough cases in and of themselves can, Tim, as you said, produce a real result even before trial, number one. But number two, can advance legal theories and strategies and changes in the law, even without trial and through trial. So that's why I think it's so important. And Soto versus Bushmaster is doing that.
Thank you. So we're getting the signal from David that it's time to conclude, but I just want to thank you for what a tremendous discussion with such a diversity of views and also productive. So wherever you are, please give a virtual round of applause to our panelists. David, Peter, Joseph, I'm handing this back to you.